1968ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်425 The Rangoon Cargo Boat Owner Association Appellant vs. MESSRS DINE Company and 1 Respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးစိန်သင်း Judge The Rangoon Cargo Boat Owners Association Appellant vs. MESSRS DINE Company and 1 Respondents Suit for recovery of damages joining both common carrier and underwriters as defendants, whether permissible under Order 1, Rule 3, and Rule 7 of the Code of Civil Procedure, causes of action against the insurance company and against the common carrier. Hell, the suit was not based solely on the insurance policy. The right to relief claimed by the plaintiff as against both the defendants arose out of the same transaction to wit, transport of pets, and if separate suits were brought against them, common questions of fact, if not of law as well, would certainly arise. Order 1, Rule 3 of the Code of Civil Procedure lays down that all persons may be joined as defendants against whom any right to relief in respect of or arising out of the same act or transaction or series of acts or transaction is alleged to exist, whether jointly, separately, or in the alternative, where if separate suits were brought against such persons, any common question of law or fact would arise. It is therefore clear that under this rule, all persons may be joined as defendants against whom any right to relief in respect of the same act or transaction is alleged to exist, where if separate suits were brought against such persons, any common question of law or fact would arise. Moreover, Order 1, Rule 7 of the Code enables the plaintiff who is in doubt as to the person from whom he is entitled to obtain redress to join two or more defendants in order that the question as to which of the defendants is liable and to what extent may be determined as between all parties. Neptune Assurance Company Limited vs. Lucky Ram, Garci Ram, AIR 38, 1951, NAC 280, refer to. It would be necessary for the plaintiff to prove in what manner the loss was incurred by them before he could enforce his claim against the insurance company. The same fact will have to be traversed in respect of their claim for damages as against the common carrier. It is therefore not quite correct to say that the causes of action against the defendant were entirely distinct inasmuch as there was at least a part of the cause of action which was common to both. People's Insurance Company Limited vs. Benoit Busan Boumic AIR 30, 1943, Kel 199, refer to. Mr. G.N. Banerjee for the appellant, U Myin So for the respondent number 2, U Sain Thin, Judge. The undisputed facts of the case, out of which this appeal has arisen, are as follows. The plaintiff, MESSRS DINE Company, charter a cargo boat, CB number 69, from the Rangoon Cargo Boat Owner Association, a common carrier for the purpose of transporting beans from Alimola Jetty to SS Sangola, which was more midstream. The beans were insured with the South British Insurance Company Limited as per Exhibit Insurance Policy, containing what is known as FBA clause, which exempts the underwriter from liability for loss against any damage due to goods coming into contact with water. On 9 April 1962, 372 bags of beans were loaded into CB number 69, which was towed to SS Sangola and kept alongside of it. The unloading began at about 2 a.m. on 10 April 1962. As the bags were being unloaded, the CB started leaking and, in spite of the attempt to bail out the water, 188 bags of beans were damaged. The plaintiff thereupon claimed from the South British Insurance Company a sum of Jet 11,000 being the proportionate insured value for the beans damage. The underwriters, however, rejected the claim on the ground that the damages were due to goods coming into contact with water, which was the result of unseaworthiness of the CB. The plaintiff then directed their claim to the Rangoon Cargo Boat Owner Association. The present appellants before me, who likewise disclaim liability attributing the loss of parts to inclement weather, faced with the dilemma as to whom rightful claim should be preferred, the plaintiff therefore find the present suit joining both common carrier and underwriters as the defendants. The learned trial judge, after a careful scrutiny of the evidence, both oral and documentary, obtaining on the record of the lower court, came to the finding that the damages were occasioned on account of the unseaworthiness of the CB, that the parts having been damaged due to contact with water, the South British Insurance Company was not liable as the policy did not cover such a loss by virtue of the FBA clause embodied therein, that the loss being directly attributable to the negligence on the part of the owners of the CB in hiring out one which was not seaworthy, the Rangoon Cargo Boat Owner Association, in their capacity as a common carrier, were liable for the loss of the parts valued at Jet 9,349.7. He accordingly passed a decree for the said sum against the appellants with proportionate costs. Hence, this appeal. There being not the slightest doubt that the beans were damaged due to unseaworthiness of CB number 69, which was hired out by the appellants in their capacity as a common carrier, the appellants were surely under a statutory liability to make good the loss occasioned by their negligence. Thus, the only point worthy of consideration in this appeal is whether the suit was bad for misjoinder of defendants and causes of action as alleged by the appellants. Mr. Banerjee, the learned counsel for the appellants, contends that the suit having been based on the insurance policy to which his clients were not parties, they should not have been joined as defendants, but it is not correct to say that the suit was based solely on the insurance policy. The right to relief claimed by the plaintiff as against both the defendants arose out of the same transaction, to wit, transport of parts, and if separate suits were brought against them, common questions of fact, if not of law as well, would certainly arise. Order 1, Rule 3 of the Code of Civil Procedure lays down that all persons may be joined as defendants against whom any right to relief in respect of or arising out of the same act or transaction or series of acts or transaction is alleged to exist, whether jointly, severally, or in the alternative, where if separate suits were brought against such persons, any common question of law or fact would arise. It is therefore clear that, under this rule, all persons may be joined as defendants against whom any right to relief in respect of the same act or transaction is alleged to exist, where if separate suits were brought against such persons, any common question of law or fact would arise. Moreover, Order 1, Rule 7 of the Code enables the plaintiff, who in doubt as to the person from whom he is entitled to obtain redress, to join two or more defendants in order that the question as to which of the defendants is liable and to what extent may be determined as between all parties. Thus, in the case of Neptune Assurance Company Limited vs. Lucky Ram, Chassis Ram 1, it was held that in a suit for damages for injuries sustained by the plaintiff while traveling in a bus as a result of rash driving against the owner and driver of a motor bus, the insurance company with whom the bus is insured against third party, risk can be impleaded as defendant under the principle underlying Order 1, Rule 7 and 10(2) of the Code of Civil Procedure. It is next contended that, as the causes of action against the defendants being different, they should not have been impleaded in the same suit. I am, however, unable to subscribe to this view. The expression causal action has been compendiously defined to mean every fact which it would be necessary for the plaintiff to prove in order to support his right to the judgment of the court, although it does not comprise every piece of evidence which is necessary to prove each fact. It does comprise every fact which is necessary to be proved to entitle the plaintiff to the degree sought for. In other words, it means the whole bundle of material facts necessary for the plaintiff to prove in order to entitle him to succeed in the suit. Thus, in the instant case, it would be necessary for the plaintiff to prove in what manner the loss was incurred by them before he could enforce his claim against the insurance company. The same fact will have to be traversed in respect of their claim for damages as against the common carrier. It is therefore not quite correct to say that the causes of action against the defendant were entirely distinct, inasmuch as there was at least part of the causal action which was common to both. For in People's Insurance Company Limited vs. Benoit, Busan, Bo Mick, and others too, it was held that in case of a life insurance policy, the claimant must prove the death of the assured before he can enforce his claim against the company, and that the debt of the issuer is thus a material part of the causal action. But even considering that the causal action against the defendants are distinct, there is no depth of authority for the proposition that two or more defendants may be joined as parties in one suit, though there are two or more causes of action, provided the right to the relief claim arises from the same act or transaction, and there is a common question of law or fact. For all the reasons stated above, I would hold that this appeal fails and is hereby dismissed with cause. Advocate fee fixed at 3 gold mohars.